So let's go into it. So asylum law. I know you said you practice a lot with a lot of South American, Central American cases. What are some tips? And people can catch the article in the second issue of the Toolbox magazine, page 74, where we go through it. But just a brief synopsis of maybe 2 or 3 of the big things that are on the horizon to watch out for when it comes to immigration, both affirmative, I guess, and defensive. You do both?
Mostly defensive.
Oh, interesting. So the hardcore end of the line, yeah.
Yeah, exactly. So mostly in immigration court. But one of the things that's been incredibly helpful during the end of the Trump administration was the fact that there was a lawsuit by ASAP and CASA against President Trump's administration's regulations concerning the length of time before someone could apply for a work permit. A lot of practitioners are aware of this, but some may not be. And it definitely is a way that can help people, because otherwise they're getting here and they have a defensive asylum case and they're waiting a year to even apply for a work permit. And then the regulation requiring that USCIS would adjudicate it within a month was also taken away. And so it'd be 3-4 months before they would do this. But now, if you get CASA or ASAP membership, I've mostly been using ASAP. They're real quick at getting that membership card to you. You apply with that, and then you apply to USCIS. For a while there, USCIS, even though you made it plain as day that they're ASAP members, they would still take forever, but you'd call 28 days in, make sure that they're part of this litigation, and then within 45 days, you got the card in the mail. So that is something that's been helpful. Another thing people may or may not be aware of is those who were subject to MPP do not have to wait the 180 days. But if they were subject to the Remain in Mexico program, then they can apply immediately, but they do have to pay the fees. That's different than a normal asylum work permit application. But right now that litigation is still pending. So people are able to apply for that work permit. It can come so much more quickly than will typically be the case if they were to apply otherwise.
Yeah, it's because I don't do asylum claims, and I have people email me and stuff, and I'm like, I knew there was something going on with this because I don't handle these cases. I didn't look into this, but I'm like, there's something going on where you don't have to wait the full year what Trump was trying to do. But I don't know the details. That's why you got to contact someone who does this stuff, does on a regular basis, and keeps on the laws. And the magazine is really helpful for sharing that information. What else is going on in the immigration in the asylum world?
Yeah, well, as well as the immigration courts itself, since that's where half of asylum is we're in the midst of reopening. So a number of courts have reopened earlier this year. But now here at Fort Snelling and many other courts, in fact, all other courts will be reopened by July 6th to some extent. So I'm having master calendar hearings for July and August being rescheduled because it seems like they're having just a limited docket. But while during the pandemic, they've only had a detained docket, they will now be reopening their non-detained docket starting in the beginning of July. What is important with that is some memos that came out earlier this year that have to do with scheduling orders. So what's normally the case for immigration practitioners, if you go in at that master calendar hearing, you'd want to have the asylum application prepared and you bring it to the judge. If there's any corrections from an affirmative filing, then you would make those corrections. But the new scheduling order, or the new memo that came out, appears to indicate that if you have an EOIR 28 filed, then very likely you may not be attending that master calendar hearing any longer, and it would simply be done by written pleadings. Now, there's a lot of consequences for this when it comes to due process, but at least for now, it appears that that might be the case. And it also is probably going to come down to each court how they're going to implement this. So here at Fort Snelling this week, there's actually going to be the chief judge and several AILA attorneys getting together. They're going to provide us a bit more nuts and bolts information about what this is going to look like at Fort Snelling. But I know many of the other courts, many attorneys are just kind of waiting to see what these scheduling orders are going to look like because a lot of info hasn't been given yet. But at the same time, it looks like that if you have not filed an EOR 28, then you may not be going to court for the master calendar hearings.
Interesting. And another thing that popped up, and I think they put on hold, which is really crazy, was the new bars to asylum and getting the benefit, which could be even as something like even smaller kind of crimes or associations. Did that go on hold still, or is that going into effect?
It is still on hold. The litigation is still ongoing, and so there's an injunction there that has not been lifted at this point.
What about the filing fee increase? Is that like USCIS where they stop that, or is the fees going up for UIR based cases?
That's a similar situation. There's an injunction against that. So these fees were going to increase astronomically. They were going to be, going from just over a few $100 to nearly $1,000 for many of them, and this would have just really cut out the feet from under a lot of people to be able to appeal their case. If you have some rogue immigration judge who denies 98% of cases, to even have a chance to appeal would have been very, very costly.
Yeah.
Especially think of those who are in asylum. Normally don't have an asylum filing fee at all. So you file affirmatively, but then it comes time to file an appeal. It's nearly $1,000 plus legal fees. So that was going to be a lot for a lot of people. And so at least thankfully now that's going to be the case. Now, it's been interesting with the Biden administration coming in. Some regulations have continued to be implemented. So it's whether or not this one will be implemented or not throughout the litigation, or if they're going to be able to publish notice of new regulations to be able to take these out in time. Who knows? We'll see.
Yeah, it's just a mess. I mean, there's so many different things. I guess we're going through the whole list of the five, but the last thing was third country transit. That's something that people are not aware of many times. Could you discuss that aspect of it too?
Yeah, so on the asylum application, it asked that question, whether or not you have gone to a third country and whether or not you have applied for asylum in that place. So that's something that all practitioners are more than well aware of, and something that could be a possible issue in the future as things change. But, the immigration courts are so backlogged. I'm telling people now, by the time your individual hearing is going to take place, there will be perhaps a different administration than even the one that's now, because they're scheduling, at least in our court, for late 2024, early 2025, probably by the time we get back to court. So whether or not it will be in effect at that time, which is the controlling law, obviously, that we'll see what happens. But at least this third country transit ban is still in litigation and has been enjoyed.
You mentioned the time it takes to get things going for court when it comes to asylum and everything in court. One of the reasons I stopped going to removal was because they would say, okay, we're going to reschedule, come back in 3 years. And I'm like, oh man, like we just did all this work in 3 years. It's just a mess. And clients would get really dissatisfied. And I still get phone calls from people saying, my lawyer sucks. It's been 3 years. I still have my court case or my affirmative asylum. I'm like, it's not your lawyer. It's the system. But how do you handle these delays? I mean, there's part of it is just the cost of it. You prep someone and then the court gets canceled and have to prep them again for a couple hours later. And then in 2 years, how do you just manage this, knowing what's going on with the case and the people following up? How have you experienced this issue personally?
Yeah, definitely. There are long litigation timetables working here, but at least during the end of the Trump administration, when people were getting rescheduled for COVID, I think there was a bit more positivity from our clients, because then hopefully the controlling law would be a little different by the time their individual hearing happens. So it was actually a good thing that it was rescheduled, as opposed to having it happen during the Trump administration's reign.